Euclid case. The U.S. Supreme Court U.S. Supreme Court takes a case called Pennsylvania Coal versus Mahon. Okay? And in Pennsylvania Coal versus Mahon, and I mention Mahon just because sometimes that's how it shows up rather than Pennsylvania Coal. It's M-A-H-O-N. Okay? So but in this particular case, the Pennsylvania legislature had prohibited mining of coal where it was going to cause subsidence of homeowners who lived on the surface. Okay, and just to be clear on this, okay, the coal companies owned the subsurface rights, the rights below the ground, which included the right to mine the coal. And any of you who are from coal country around here, you know that those coal companies, way back in this time frame, paid landowners not very much money at all for those subsurface rights. And basically it would basically pay people who didn't have much money. And so any amount of money seemed like a good deal, right? And so people sold their subsurface rights not knowing what it meant, which meant, among other things, that their houses could sink or collapse when the coal company came in to mine the coal. And so obviously, there's a whole variety of public interest, public welfare issues, public safety issues. And so the Pennsylvania legislature prohibited coal mining in these circumstances, and the U.S. Supreme Court says this is a taking of private property. And the court says when a regulation goes too far, it will be deemed a taking. So the justice in this, the majority opinion in this case was Justice Holmes, Oliver Wendell Holmes Jr. Actually, the dissent was written by our own Justice Louis Brandeis, who said, there's, public interest in this, and so we should not be doing this. But up until this point, it had generally been thought that takings were actually only taking ownership of the land or taking physical control of the land. And now we have an idea that a regulation can be a taking. But Justice Holmes did not say how far is too far, and so for several decades, we didn't have a whole lot of action. And then in the last maybe 3 decades or so of the 20th century, all of a sudden we started getting a whole lot of development of regulatory takings doctrines or regulatory takings rules by the U.S. Supreme Court. So this is actually not the chronological order, but this is the order in which you need to think through the analysis. So the starting point is when a regulation goes too far, it will be deemed a taking. Pennsylvania Coal. First, basic principle. How far is too far? Well, the Lucas versus South Carolina Coastal Council, the U.S. Supreme Court says that a government regulation that deprives a landowner of all economically viable use of their land is a per se taking. So that per se thing again, automatically a taking, unless the regulated use was not part of the property owner's rights under background principles of state property law. Thus, the regulated use was not part of the property owner's rights under background principles of state property law. So, what does this mean? Okay, so first of all, the focus is on the idea that a property owner has the right to make an economically viable use of their property. That the court uses, this is actually Justice Scalia who writes the majority opinion, and he uses the words economically viable, economically beneficial, and economically productive, and they're all synonyms. He means the same thing for all of them. Okay? What is important here is to understand that this is not about the value of the land. It's not about the value of the land. It is about being able to make an economically viable or economically beneficial use of the land. Lots of land cannot be used in any economic way, but it still has some residual value. Okay? There are very few circumstances in which land is truly rendered valueless. And it's almost always circumstances where the land has some value, but the liabilities associated with the land, maybe because of contamination, because of liens on the property, or something like that, exceeds the value. So it's very rare that there's actually no value at all. Okay? So the focus is on, can the landowner make an economically viable use of the land? The exception, so there's a basic rule and then there's an exception. Okay? And the rule is a per se rule, but there's the exception is what happens if the regulated use is not something that the landowner had a right to do anyway under their property rights. It wasn't part of their property rights. And so another term that Justice Scalia uses is does not inhere in title. Does not inhere in title. Okay? Again, you're like, okay, what's up with the Supreme Court justices and wording things in awkward, confusing ways? What that means is it's not inherent in title ownership of the land. That your ownership does not inherently include the right to do this. And so Scalia offers two examples. First of all, you do not have a right to use your land in a way that causes flooding on your neighbor's property. That actually is generally true in the United States. It is not true in Indiana. Okay? Yes, exactly, Indiana. What can you say, right? So Indiana follows what they call the common enemy doctrine, where it is okay because everybody it's a sort of a survival of the fittest, right? Everybody looks out for themselves by trying to get the flood water off of your property, and so if you're able to get it off of your property and send it to your neighbor's property, then more power to you. So that happens. And by the way, there have been efforts to get the Indiana courts to overrule this because it comes from England a long time ago. It's an archaic doctrine and it's stupid. Okay, so I am being a little bit more opinionated today. But it's a totally stupid rule, and everybody agrees so, and yet the Indiana courts are reluctant to overrule it. Now, having said that, I haven't checked in the last 2 or 3 years to see if it's still good law. So it's possible the state legislature stepped in and changed it, or the courts have changed it, but that has historically been the rule in Indiana. But nonetheless, according to Scalia, this is one of the things that property owners generally, like in all the other states, cannot do.
How is it still holding up in Indiana?
What's that?
How is it still holding up?
It's just because the courts don't want to. They don't want to change the rule. I mean, actually what they want is for the state legislature to change the rule. And I don't know why the state legislature can't get its act together.
I'm surprised more people are not complaining.
Yeah, well, I don't know. The other example, the other exception that he talks about is a property owner does not have the right to use their land in a way that causes a nuisance. Okay? And so the example he uses is, let's assume we have a piece of land that has been developed for, by private property, developed for a nuclear power plant. Okay? And so the only use that now can be made of that land is nuclear power plant, right? Everybody, right? You can't just suddenly convert the nuclear power plant to, a shopping mall or affordable housing, right? I mean, it's contaminated, it's radioactive, right? And then it's discovered that this nuclear power plant sits astride a major earthquake fault. Serious public harm if there's an earthquake, and so the government, by regulation, requires the nuclear power plant to be shut down. No use can be made of the property, right? No economically productive use can be made of the property, right? Because the only thing it can be used for is a nuclear power plant, and now the government has said no. But operating a nuclear power plant on top of a major earthquake fault is a nuisance, right? It's caused serious public harm, right? Too bad, right? No takings, no requirement that the government compensate the power plant operator. Okay, so that's the gist. Let's look at what's happening in Lucas versus South Carolina Coastal Council. All right, so the land in the case was on the Isle of Palms in South Carolina. Anybody been to the Isle of Palms? Okay. All right, so this is coastal property, a lot of development, and we're now past the words, and let me see if we can get that, so you can see the pictures a little bit better. Okay, so this is the ocean out here, and this is the beach, and these are David Lucas's 2 properties in an area in which every other lot, all the other lots except his 2 lots have been developed by these small little modest, inexpensive, right? I mean, okay, look at this. This is monstrous, right? You know, it's a house, somebody's house, or the Hilton, right? I mean, right? I mean, these things are huge, right? This is pretty good size. That's not tall, but wide, and this thing's huge, right? Okay, so lots of development that has already occurred. Then the state of South Carolina, being worried about coastal erosion, hurricanes, okay, so this is in the wake of Hurricane Hugo, caused a lot of damage and so forth, and public safety, says no more development on the beaches, all right, in these certain areas. So they passed the South Carolina Coastal Act. And they say no development allowed at all. Now later on, eventually later on, they amend the act to allow for a permit, so you could get like a variance. But basically, at the time that this is litigated and time it goes to the Supreme Court, that there's no development allowed on Lucas's lot. Okay? No development. And Lucas brings a lawsuit and claims roughly about $1 million requests $1 million of compensation for a taking, okay? Regulatory taking. The Court of Common Pleas in South Carolina, so that's PLEAS, meaning like pleadings, okay, not pleas, but pleadings, and so forth, and not peas, okay. So this is the trial court in South Carolina, and the trial court finds that the regulation has rendered Mr. Lucas's property valueless. Okay, would you pay Mr. Lucas $50 for that property? Of course you would. I would. I mean, of course. I mean, now they'll just go sit on the beach, right? Okay, so you can't develop it. It's truly not valueless, right? I mean, so that's what the trial court finds, but that can't be true. Can't be true. Nonetheless, Justice Scalia and others on the Supreme Court have been looking for this kind of case very specifically. They have been strategically looking for this case. Why? Because they now have a trial court fact finding, and the basic rule in appeals in law is the appellate court cannot overturn the trial court's fact finding unless it's clearly erroneous. Okay? And I cannot tell you how many lawyers go and try to relitigate the facts in their case before the appellate court and get shut down brutally. And I mean brutally, right? Because the standard of review is the appellate court is bound. The appellate court is bound by those trial court findings unless they're clearly erroneous. And usually what happens is you have these lawyers who are like unhappy that the trial court found for the other side, and they want to relitigate it. Okay? No, not the thing. Not the thing to do at all. So, in this particular case, and by the way, the theory behind that, if you were curious about the theory behind that, The trial court sees. The trial court sees the evidence. They hear the witnesses. They see the perspiration on the brow of the witnesses as their beady eyes dart back and forth. And so they can weigh the value of the evidence. They see the smoking gun, like literally smoking right in their hands and so on. Right? So you get the idea. Right? And so the appellate court gets what's called the cold paper record. And it really, literally, I mean, I clerked for an appellate judge back then, and we got all electronic stuff now, but it actually literally came to us in cardboard file boxes of printed record, okay? And so that's what you get. So, I mean, you're just reading, okay? So the idea is that the trial court is the right court to hear this. Okay, so so we're waiting for this to. So actually, in this particular case, I think they could have said it's clearly erroneous because I mean, how could it really truly be valueless? But that's not what they did. Anyway, the appellate court can determine that a fact finding is clearly erroneous. But what they're doing is they're looking at the evidence that appears in the record, and they're saying there's a mismatch to what the court found. Okay? All right. So now, so Lucas wins. Right? The court determines there's a regulatory taking because there's no economically viable use of the land. He cannot develop it. Right? And so he gets $900-something thousand of damages. Okay? And of compensation. So then the state of South Carolina takes title to the property, takes ownership of the property, immediately lifts the restrictions, and markets the property for development for houses in order to get their money back. Okay? So that's exactly what the majority was concerned about. That's exactly what the majority is saying. In essence, of course the government will regulate property very robustly, very extensively if they don't have to pay for it. But if they have to pay for it, then now all of a sudden it's, they have to make a choice. Do they really want to regulate or not? So, remember the big monstrous house? Right, and this is Mr. Lucas here. The big monstrous house, you remember that one? Looks like a mausoleum or something. Okay, over here is one of the houses that was developed. Right? Small, tiny, modest little house, right? So there's like, whatever, 3 or 4 levels to that, and so forth. There it is from another direction. Right? Yeah, actually, I really think that's a hotel. So, right? It's a big house, right? Okay. So, again, part of what I'm trying to show here, okay, there's lots and lots of regulation that does good things. But what I'm trying to show here is that there are these sort of aftermath stories that suggest that, okay, it's, there may be more going on here, and that, there's this sort of tension or conflict over at what cost do you limit land development and so forth. All right, so having said that, let me give you the flip side of the story. So one of the things that happened when this came down is there was great weeping and gnashing of teeth among environmentalists, planners, and scholars, especially legal scholars, who were saying, oh my gosh, this is the end of land use planning and regulation and environmental protection as we know it. And at the time, I've tried to, I'm being sort of relatively opinionated today, just partly to stimulate keep you awake and stuff. But I probably think nobody is surprised that I think that there are a lot of good things to environmental regulation and land use regulation personally. It's just I tend to think those are sort of good purposes. But I read the opinion and I'm like, I don't see the cause for concern. I'm like, I don't think, you know, it's like The Princess Bride, right? That word, I don't think it means what you think it means, right? Okay. So you guys need to get out more. But anyway, so my point is that I was like, I don't really understand, because how often does a piece of property really have no economically viable use to it, right? I mean, really, not very often. Moreover, the exception, there are lots of things that private property owners do not have rights to do. There's the nuisance doctrine, but there's the public trust doctrine, and there's a whole variety. There's a doctrine against waste. I mean, there's a whole variety of different doctrines out there that inherently limit private property rights as part of property law, right? As part, you know, so no, property owners don't necessarily have these inherent rights. So I just didn't see this as having a huge effect. So, interestingly enough, two of the people who were most upset among legal scholars, eventually, I don't know, some 15, 20 years later, both wrote articles about how actually all kinds of regulation does not qualify as a regulatory takings under Lucas, and how this exception is really big and it includes all these different things. And so it has not had the effect that they were worried about. And they admit it. They said that they'll say we were wrong. So, and this is one example. And I'm going to show you next week another example where what people thought the effect of a takings case was going to be, turned out not to be it at all. Okay? So again, trying to push on you to think about really how does it work in the real world. So given the fact that there are not very many cases where a landowner is truly denied all economically viable use of their land, or even if they are, you know, in many cases the exception will apply, the Lucas exception will apply, and so they will not get compensation. Is that the end of the story? And the answer is no. In 1978, the U.S. Supreme Court articulated a test in a case called Penn Central, which is called the Penn Central Balancing Test. This is the Penn Central Balancing Test, and it says a government regulation that's not a total taking of the property may still nonetheless be a taking depending on the outcome of an ad hoc balancing test. Okay? And so ad hoc balancing test, another term that is used is context-specific factual inquiries. And another term that is used is a totality of the circumstances analysis. Okay, so what we're doing is looking at the very specific facts or context of the case and balancing these three factors. The first is the economic impact of the regulation on the claimant. Okay? Economic impact of the regulation on the claimant. What does that mean? Diminution in property value. How much was the property worth before the regulation? How much is the property worth after the regulation? What's the difference? Big difference, little difference, whatever. Okay? And don't forget, remember in Euclid, zoning was upheld despite a 75% loss in value. Okay, 75% diminution in value. Second, what is the extent to which the regulation interferes with distinct and reasonable investment-backed expectations of the landowner? So, did the landowner invest in the property with a set of expectations to develop a certain way, had clear, well-developed expectations, and those expectations were reasonable under the circumstances? Okay. And third, what is the character of the government action? how important of a government purpose is served, and how tailored is the regulation to that purpose. Okay? The bottom line here is the government wins these cases more than 90% of the time. Okay, so empirical analyses of all Penn Central takings claims that have been brought over the years, well more than 90% of the time, the landowner loses, no taking. Okay, so it's a balancing test. Why? Well, the economic impact could be variable, right? We have one case where the landowner won with somewhere between 35 to 40% loss in value. It's an unusual case, but usually you have to get pretty close to 100% loss in value to be able to win. Okay, so oftentimes the loss in value is not, even though it might be substantial, is not considered to be enough. Secondly, very often the idea is landowners, developers should expect for regulations to change. Okay, they are buying and developing in an environment in which government is trying to identify harms that can come from overdevelopment and change the regulations to adapt to that. Third, very often the government regulation is serving important purposes and is not too overly broad. Okay? Now, sometimes governments get carried away. They do overbroad regulation and so forth. But in general, the idea is that's the case. Also, the other thing to think about that is if the character of the government action is not sufficient to support the regulation, very often the courts don't ever have to get to takings because they're going to actually invalidate the government regulation. So, for example, maybe it's ultra-virus because there's no land use nexus. Oh, Professor Arnold, there's a land use nexus thing, but I'm telling you, it's a real thing and it's a real issue. And so if there's no, so if the character of the government action is they're using land use regulatory powers overly broadly where there's no real impact, if they're not really regulating the impact on surrounding land uses, well, it's more likely the court's just going to invalidate the action rather than say there's a taking. Does everybody see that? Okay, so these are not big winners for property owners. And in this particular case, we have historic preservation. Now, this is a somewhat difficult slide to see because this down here, and you can't see all of it, but this is the Penn Central station in Manhattan, in New York City. This is actually on the block behind it. This Pan Am building is actually the block behind it. So it's hard to show the picture in good 3D imagery, but the idea here is the developer put forth a proposal to build a 50-some story office tower cantilevered on top of the historic Penn Central station. Okay? And you see them, there's a lot of tall office towers around and so forth. But the idea was to put it on top of the Penn Central station. And there's historic preservation regulations that required permit approvals, and the government turned it down. And the landowner the developer brought takings claim, and the U.S. Supreme Court says no takings. There's no taking here for a couple of reasons. Well, actually, it's for several reasons, but one is the landowner is seeking to do something very intensive on a historic building, right? On a historic building. Moreover, the landowner had, I don't know, I think they had a 54-story proposal and then like a 52-story proposal and nothing less. So they didn't try for anything less. They didn't even try to seek out whether the government would approve, say, a 30-story office tower on top of it, right? So that was a problem. The court says historic preservation is a valid purpose for exercising land use regulatory powers. Okay, so AICP takers, that's an important point. Okay, Penn Central is where the Supreme Court expressly recognizes that historic preservation is a valid exercise of the police power using local land use regulatory powers. Okay, that clarified that issue. The other thing is that the property was already being used for commercial and retail purposes. They had offices, stores, restaurants in the Penn Central station. So there was already an economic use that was being made. What is it that made this developer think that they were going to be entitled to then add 50 more stories of office space on top of it? And then finally, the court says, well, the city also offered the developer, as part of this, TDRs, transferable development rights. And so basically what it meant is that in order to preserve this historic building, the landowner then would be able to, on another site, or transfer to an owner of another site the right to build something a lot taller than the local zoning allows. So if the zoning, say they got TDRs for 30 stories and the zoning limited office towers to 20 stories, right? Then whatever was the receiving property of those TDRs could then build 50-story building. Does everybody see that? And so the idea was that was something of value that the city provided as an offset for the regulation. Okay, so no taking in that case. All right, so let's now turn to the Palazzolo versus Rhode Island case. So this is 2001, and the U.S. Supreme Court does several different things in the Palazzolo case. Okay, so this is a situation where a property owner owns some 18 acres of land on coastal wetlands along the Rhode Island coast, right there and the Atlantic Ocean. And they want to do this massive residential development there, and the Rhode Island, the state of Rhode Island prohibits the building of anything other than one house worth $200,000 on an upland bluff portion of the property. And at the time, so actually part of what happens here is the property is owned by a company, and the company is owned by Palazzolo. The company basically goes out of business. But the thing is, it actually loses its business license, so it's dissolved by the state. So then Palazzolo, as an individual landowner, becomes the owner. And so part of Rhode Island's claim is that Palazzolo does not have the right to compensation, does not have a valid takings claim because the regulation was inherent in Palazzolo's title at the time that Palazzolo acquired ownership of the property. And so basically the idea is, can the regulation be a limitation inherent in private property rights? And the U.S. Supreme Court says no, that regulations are different. That what they're talking about are property law limitations that are inherent in property ownership. And basically what they said is, if every regulation was an inherent limitation in property rights, there'd be no takings credits, right? Because the whole point is the regulation a taking? Well, if the existence of the regulation is a limitation, then that's, so they don't like that. But what's interesting is every single justice, from the most liberal to the most conservative, is in total agreement that there is no Lucas taking claim here. Okay, 18 acres could be worth $3 million or more if developed, but one home worth $200,000 is an economically viable use of the property. Okay? They said, hey, homes are economically valuable. This is not a case where the landowner has no use of the property. So one home worth $200,000 on an 18-acre parcel of land, arguably worth over $3 million, is still nonetheless an economically viable use. Did you see why I said, all the way back when this came in, I'm like, it's not that big a deal, right? I mean, you can establish an economically viable use, and that's what it's turned out to be, okay? And this is all the justices, right? I mean, there's no split on this, okay? So then what happens is, because there's no Lucas taking, it gets sent back to the Rhode Island courts for a Penn Central analysis. And there's a little sort of debate going on in the concurrences between Justice Scalia and Justice O'Connor, where the question is, does the existence of the regulation at the time you acquire the property affect your reasonableness of your investment-backed expectations? And O'Connor says yes, Scalia says no. Well, we don't have to worry too much about that, because on remand, the Rhode Island courts say, remand means just goes back down to the lower courts, and then the Rhode Island courts say there's no Penn Central taking, because first of all, there's evidence in the record that the developer physically could not build the project that they claim. So they had testimony by a licensed engineer that said at least half of the properties, the soil was, half of the intended lots, right? He was going to subdivide this into lots. And at least half of the intended homes that he was going to build, at least half the intended homes, the soil was too wet and would not physically support the weight of a home. The home would sink into the mud. Okay, so not even physically possible. Yeah. So that's about half the homes. Then, secondly, the court said that all the homes were going to be served by septic systems, which leak, right? Anybody familiar with septics? They leak, right? And that was going to contaminate the groundwater, which it constitutes a nuisance, right? And you don't have the right to use your property in a way that causes a nuisance. So, water contamination is one of the kinds of things that can be used to say, hey, there's no taking here because you never had the right to do that. Third, some portion of the property was under what's called the mean high tide mark. So the water came in and out and so forth, but it was within the area that is subject to the public trust. Okay, so the public trust doctrine is an ancient Roman doctrine, and it applies to states in the United States. How it applies, it varies a little bit from state to state. There's a lot of disagreement whether there actually is a uniform public trust doctrine, whether we should have one, whether there are U.S. constitutional foundations to the public trust. Lots of disagreement, but nonetheless, in Rhode Island, land that is below the mean high tide mark is considered subject to the public trust. So coastal wetlands that are regularly flooded by the tide are subject to the public trust, and therefore you cannot build on them, right? So the idea is that these are, even if they're privately owned subject to the public's interest because of the public trust. Okay? And so that's a limitation inherent in title. Okay? A limitation inherent in title. So bottom line is no development. Okay? So there is a picture of the property, right? This is very blurry, but the site's out here. Here's the ocean. The road's over here. Any developments on the other side of the road, okay, right? Okay, so now we're starting to see some patterns here. There was a case in New Jersey having to do with wetlands, federal regulation of wetlands, where all of the area all around it had already been developed, and those wetlands had been filled, and there was one parcel left, and the landowner was not allowed to develop and claimed a regulatory taking, and the federal courts said, yes, this is a regulatory taking, right? Why? The court actually said expressly, you allowed every other land developer all around you to develop, and you allow the building of the wetlands, and now when you're left with this one last remnant piece, right, you're not allowing this landowner to develop. And so if you want to prevent the development, that's fine, you just have to pay the landowner for it, right? So that was a New Jersey, it came out of New Jersey. So, so let me actually jump ahead to, on that point, to this. So this is the Del Monte Dunes case. So I'm going to come back to what the legal test was in Del Monte Dunes, okay? But one of the, so this here is the property. So this is Monterey. This is Pacific Coast Highway here, right? Pacific Coast Highway. And this is apartments. This is a public park. And so this is a landowner's land, and he wanted to build a housing development. This is property that at one time had oil wells on it and had a lot of sort of remnants of these oil wells, okay? And it basically is sort of sand and scrub, so shrubby type of stuff. And the shrubby type of stuff is an invasive, some sort of ice plant type, I think is what they call it. But anyway, it was a sort of invasive plant that had developed up along the coast and so forth. And so you can see, like, it's not much happening there. These things are some of the concrete foundations on which some of the oil pumping equipment was and stuff, okay? So, so what happened is the city of Monterey, it is different entities. Sometimes it's the planning commission, sometimes it's the city council, but basically, along the way, what happens is the developer proposes, lots of homes, massive high-density development, and the city articulates concerns about the land use impacts, about the viability, the appropriateness of such an intense development on traffic or on the public services or on the adjoining park and so on and so forth. And so what happens is every time the developer comes and files an application for a permit, the city says, this is too much. But if you bring us this smaller development proposal, and they usually state with some specificity what they will approve. But they say, if you bring us a smaller proposal, we will approve it. So the developer goes back, redesigns it, brings the smaller approval, or smaller project, a smaller proposal, and the government denies it and says, no, we now have this new concern, right? So they go from traffic to impact on the parks. So near the end of all this, and so he goes through 5 or more different proposals. It's unclear, somewhere between 5 to 8 proposals. But at some point, they say, well, this is a site where there is an endangered butterfly. It's habitat for endangered butterfly. And so we can't allow you to develop here. So so the developer finally sues, and says, I have a takings claim. One of the things that the city argues is, well, his claim isn't ripe yet to be heard by the courts because we might approve some smaller development, right? So that he hasn't tried for something yet smaller. And one of the things the Supreme Court says is, well, it's clear that they're not going to approve anything, right? I mean, after 5 to 8 different applications saying they'll approve the next one and then not approving it, right? It's clear they're not interested in approving the development. Okay? The majority opinion written by Justice Kennedy starts out. This is hardly a environmentally pristine site. Okay, right? You don't even need to read any further. You know what the outcome is going to be, right? It's going to be a taking, right? I mean, don't pass go, don't collect $200. It's immediately going to be taken, right? Okay, so you know that, right? And so so Kennedy goes on, and one of the things he says is the only evidence. Okay, so he says this is a hardly pristine site. There's been a lot of development, resource exploitation, this invasive shrub, and the only evidence of this endangered butterfly has been one dead larva. One dead larva. So again, right, you know, like this is not going well for the city. Well, actually, the city already knew it wasn't going well when Justice Breyer. Okay, so Justice Breyer, who actually ends up in the minority saying this is not a taking, but nonetheless, during oral argument, Justice Breyer asked the city attorney whether bad faith could be a legitimate government interest. Sit down, forget it, you're in trouble, right? I mean, your case is not. What Breyer is saying is the city has not been acting in good faith with this development. Right? Because they keep saying, we'll approve something lesser, and then when it comes along, they're not approving. Okay? So that's what's going on in this case. Now, I mean, having lived out in California, near the coast, being familiar with this, okay, there is no question that this parcel has some environmental value and that development will have impacts, okay? So that is clear. But, again, look at the pictures, right? Look at all that massive development around one remaining parcel of land, okay? So this is not a rule of law. There's nothing that the court ever says about this. But I will tell you with great confidence that if you just look at the property that the court involved in a takings case, and if it is like the Palazzolo land where it's environmentally sensitive and mostly undeveloped around it, it's not going to be a taking. When it is the last piece of undeveloped land where development has been allowed all around it, it's going to be a taking, right? There's compensation is going to be due to the landowner. And whether that should be the case or not, we could have a very interesting discussion about that, but all I'm saying is, as a practical matter, and that's not a rule of law, right? You can't say that, but just practically, that makes a difference. So, when you are working with regulators, you need to be cautious about this being sort of your last stand, right? I mean, again, you know, I know people sort of said, well, we're never going to see any improvements to, you know, West Broadway if we keep allowing this. But look at all that development is really only the YMCA, right? Which is a totally different kind of development, right? But, you know, just all along there. And that makes it very difficult. Okay, but what's the answer? The answer is public investment of public dollars, right? I mean, I mean, whether it should be or not, and whether that's, you know, that's bad for the environment, or it's sort of, you know, I mean, there's lots of ways to critique that, but nonetheless, what I'm saying is that when the government has allowed a bunch of development to occur, to suddenly stop with somebody and say, no, we're not gonna do that, it gets tricky, okay? So, anyway, let me go back one slide and just clarify. So, the question is the government regulation a taking if it fails to substantially advance a legitimate government purpose? What does that sound like? That sounds like due process, right? Substantive due process. That sounds like the Euclid test, right? Different source of law, different source of the Constitution. So in 1980, the Supreme Court used that test. In Del Monte Dunes, the Supreme Court used that test and said, well, when this came to trial, this was still good law, but by 2005, in a case called Chevron versus Lingle, which is actually another Hawaii case, but the US Supreme Court says, no. The substantially advances a legitimate government interest is a substantive due process test. Has no relevance to takings analysis. So they overrule, and they very explicitly overruled Higgins. Okay, they're like, no, sorry, not good. So, so in other words, don't get caught up in the substantially advances test in takings. That's a totally legitimate substantive due process claim, but not takings. Okay? All right. I know it's a whole bunch of things that we covered.
So you're saying that they denied all their development so they could take it?
Well, basically what they wanted was, so the city of Monterey, what they really wanted was for the land to remain undeveloped, because it basically provided a buffer between these apartments that were already there, the Pacific Coast Highway, which is pretty heavily traveled, and the park. And so the bottom line is, that was really what they were doing, okay?
So the landowner got.
Compensation, yeah. And it was over $1 million. I forget exactly how much it was, but it was, yeah. So, yep, compensation. All right. So, probably most of you have not looked at the Stapleton Ridge stuff, because it just got up on Blackboard a couple days ago, but it's there, okay? I do think it would be wise in the remaining few minutes left in class to at least just kind of convene with your team, touch base, and I will come around and answer any sort of preliminary questions that you might have, the things that might come to you. But the main thing is just to start getting organized on Stapleton Ridge, because the problem is you're going to run out of time in class because of where spring break falls, right? And I'm feel fairly certain some of you will not be around during spring break, so you want to get a better sort of head start on that. So we'll break for that, and we'll finish up takings next week. And I will post, by the way, I will post these PowerPoints also on Blackboard.
All right. I was gonna steal